A Broward County judge is now under investigation. Judge Gina Hawkins was caught on surveillance video putting her hands around the neck of a man and then shaking him.
A local judge's career on the line after here at the courtroom in Brevard County, what begins as a verbal fight with an attorney turns into a physical fight in the hallway.
The FBI has arrested a Wisconsin judge over allegedly helping an undocumented immigrant evade arrest.
One judge punches a defense attorney right in the middle of court. Another drops a loaded handgun while strolling through the courthouse hallway. Both caught on camera. But believe it or not, these aren't even the worst things judges have been filmed doing. So, here are some judges who forgot there were cameras in court.
Judge Dugan was arrested last month for allegedly helping a wanted man evade arrest by federal immigration agents.
The video shows Judge Hannah Dugan interacting with federal agents outside her courtroom, then directing them away as Eduardo Flores Ruiz left the courthouse and ran from them.
This was the moment Milwaukee County Circuit Court Judge Hannah Dugan made a bold and highly controversial move by leading U.S. immigration officials away, giving an undocumented alien immigrant the chance to slip out and avoid arrest. But what she didn't realize was that this whole thing was caught on surveillance cameras. This illegal immigrant in question here is Eduardo Flores Ruiz, a Mexican national who'd been deported back in 2013, but illegally re-entered the U.S. According to reports, Flores Ruiz was hit with 3 misdemeanor battery charges, with added modifiers for domestic violence and causing physical harm, after things got way out of hand over a noise complaint. His roommate called him out for blasting music too loud, and in response, Flores Ruiz allegedly punched this guy 30 times. And when the roommate's girlfriend tried to step in and break it up, he reportedly turned on her and beat the crap out of her too.
He punched him with a closed fist in the face 30 times. He punched a woman in the face with a closed fist so hard she fell to the ground.
After the incident, Flores Ruiz was arrested, and that's when ICE agents were notified of his presence in the U.S. So they set their sights on arresting him after his pre-trial hearing, scheduled for April 18, 2025. However, that plan gets soiled by a judge who, for some reason, wanted Flores Ruiz free. On the day of his pre-trial, about 6 federal officers from ICE and the FBI plus DEA had shown up at the courthouse intending to arrest Flores Ruiz. With them, they had this administrative warrant due to his illegal re-entry into the country, and they recognized him after his prints were uploaded to federal databases. As you can see here, those 2 federal agents confirmed his identity after Ruiz walked past them with his attorney, Mercedes de la Rosa, headed for his hearing in Judge Dugan's court. But a moment later, Judge Hannah Dugan and this other judge approach the agents sitting on the bench, and they tell them they need a judicial warrant and had to speak with the chief judge of Milwaukee County before making any arrests. Now keep in mind that 66-year-old Judge Hannah Dugan became a judge after spending a lot of her career providing legal services for poor people and specializing in housing and public benefits. In 1995, she represented who panhandled on downtown sidewalks, arguing that barring them from doing so was unconstitutional. Now, she was elected judge in 2016 and ran unopposed for re-election in 2022, and her current term is supposed to end in 2028. So, given her status, those federal agents had no choice but to respect her authority. Yet this is where it gets interesting. After sending those agents off to the chief judge, Hannah Dugan ushered Flores Ruiz and his attorney through a side door meant for jury members and led him secretly back into the hallway. But one agent spotted him. He signaled to the other federal agent, leading him to trail Flores Ruiz down to a non-public area of the courthouse before he left the building. Now, the moment Flores Ruiz got out, he tried running away, but those feds caught up with him, leading to his arrest just about a block away. And while all this was happening, a state prosecutor and the victims of Ruiz's assault were waiting for him in Dugan's courtroom. But she removed that case from her docket without telling anyone why. April 25th, 2025. Hannah Dugan's arrested by the FBI. Now she's facing 2 federal charges, one felony count of obstructing a U.S. agency, which carries a penalty of up to 5 years in prison and a $250,000 fine, and one misdemeanor count of concealing a person to prevent arrest, which could mean up to a year in prison and a $100,000 fine. Altogether, she's looking at 6 years behind bars, with up to $350,000 in fines. On May 13th, 2025, she's suspended by the Wisconsin Supreme Court from serving as a circuit judge and officially indicted. But 2 days later, Dugan pleaded not guilty to both charges. Her legal team, led by former U.S. Attorney Stephen Biskupic and former Solicitor General under President Bush, Paul Clemente, filed a motion to dismiss the case. They argue she has judicial immunity for actions taken in her official role and citing a Supreme Court ruling on presidential immunity, claiming that her motivations are legally irrelevant. Nonetheless, her trial is set for July 2025.
The action a judge took against a teenager on a field trip to his courtroom has some asking, is he out of order?
The judge, who says he's since received violent threats, removed from his criminal case docket as he undergoes, quote, necessary training, according to the court's chief judge. Wayne State University also tells NBC News he's been removed from teaching classes there.
On August 13, 2024, Judge Kenneth King of Detroit's 36th District Court made headlines for ordering Eva Goodman to be handcuffed and put into a jail uniform during a courtroom field trip. The reason? She fell asleep and, in his eyes, showed a disrespectful attitude. Now, Eva was part of this vocational program run by the nonprofit The Greening of Detroit, visiting King's courtroom to learn about the justice system. However, while presiding over the criminal division, Judge King noticed Eva dozing off during his presentation. He issued a warning to her by saying,
"You fall asleep in my courtroom one more time, I'm putting you in the back, understood?"
But when Eva nodded off again, King followed through with his words. He orders court staff to detain her, had her change into a Wayne County jail jumpsuit, and placed her in handcuffs. She was then kept in a holding cell for about 2 hours. As if that weren't enough, King proceeded to stage what he described as a mock trial, asking Eva's peers to vote on whether she should be sent to juvenile detention. He later admitted that there was probably no real chance of actually jailing her, and he also claimed the whole episode was meant to teach Eva a lesson about courtroom respect, saying her attitude and disposition were the real problem, not just her sleepiness, which he acknowledged isn't unusual, even amongst lawyers.
That's not something that normally happens, but I felt compelled to do it because I didn't like the child's attitude. Was I really going to do that? Probably not. Could I have? Probably so.
The incident was live-streamed on the court's official YouTube channel and quickly went viral, sparking outrage over what many viewed as an excessive and inappropriate show of power. Eva's mother, Latoria Till, revealed that her daughter had likely been sleep-deprived due to their unstable housing situation, which left them bouncing around and up late the night before.
So the fact that he was talking about you go home and get in your bed, how do you know my baby got a home? How do you know my baby got a bed, her own bed that she can sleep in? She don't have that right now.
She called the judge a big bully and said that her daughter Eva was traumatized, humiliated in front of her peers, and scared to return to school. Of course, Judge King tried defending his actions, but other professionals in his line of work definitely felt that he went too far.
Just totally inappropriate. There were so many other ways in which to have helped that young girl learn.
The nonprofit also joined in to condemn King's behavior, stating that he could have simply asked the group to leave if he felt disrespected. Legal experts also said King likely violated standards of judicial conduct by failing to avoid even the appearance of impropriety. And as such, Judge King, or should we say Mr. King, was benched. August 15, 2024, Chief Judge William McConaughey removed King from his criminal case docket and ordered him to complete necessary training, though he continued receiving his salary. McConaughey stressed that the court, known as the People's Court, was meant to be a space free of intimidation, and King's actions didn't align with that mission. Then, on August 21st, Eva's family filed a 56-page federal lawsuit through Fieger Law, targeting King and 2 unnamed court officers. Now, the suit accuses them of malicious prosecution, false arrest, false imprisonment, unlawful seizure, and intentional infliction of emotional distress. They're seeking $75,000 in damages for Eva's pain, suffering, and psychological treatment. The lawsuit would also claim that King didn't have judicial immunity because the court wasn't officially in session, making his actions extrajudicial, especially since Eva hadn't committed any crime. It further noted that Eva's emotional reaction was worsened because she was reliving trauma from a past homicide case hearing, which contributed to her disengagement that day. King's lawyer, Todd Perkins, declined to go into specifics, but said the judge only wanted the best outcome for Eva and other youth. King himself expressed regret if Eva had been hurt, even offering to mentor her, a gesture the family declined. He also said the situation had been blown out of proportion and claimed that he too had been traumatized by the fallout. By September 26, 2024, Judge King was back on the bench, but with a significant demotion. He's reassigned to the Traffic Division, where he now handles lesser offenses like speeding tickets rather than major felonies. Meanwhile, Wayne State University, where King had been this adjunct professor, pulled his fall courses and removed his profile from their website. So as of now, we don't know how that lawsuit is turning out, but from everything Judge King has gone through, with the media backlash and that demotion, we can say that justice was served to the very hand that was supposed to serve justice.
Breaking developments after a Cook County judge is caught sneaking a gun into a prohibited area of the courthouse.
On July 3, 2018, longtime Cook County Circuit Judge Joseph Claps found himself in legal trouble after a courthouse surveillance camera caught him dropping what looked like a loaded handgun in the lobby of the Layton Criminal Court building in Chicago, the same courthouse where he'd worked for over 2 decades. The incident happened around midday. Claps, 70 years old at the time, was walking through the lobby with his suit jacket draped over his arm when a silver-colored object, believed to be a pistol, slipped out and hit the floor. 2 nearby sheriff deputies noticed the fall but didn't immediately react. They're unsure whether judges were exempt from the building's strict no firearms policy or not. But Claps did have both a valid firearm owner's identification card and a concealed carry license. However, that doesn't necessarily give him a free pass inside the courthouse. Those sheriff deputies eventually reported the incident to their supervisor, and after reviewing the surveillance footage, the Cook County Sheriff's Office charges Claps with carrying a concealed weapon in a prohibited area, a Class B misdemeanor. That charge could have landed him up to 180 days in jail and a $2,500 fine. But due to Claps's close professional ties with many Cook County judges and prosecutors, the case was handed off to Will County Judge Edward Bermilla to avoid any potential conflicts of interest. A special prosecutor from the Illinois State's Attorney's Appellate Prosecutor's Office was also brought in. Now, while the case was pending, Claps was pulled from his judicial duties and reassigned to behind-the-scenes work, things like legal research or administrative tasks. His arraignment, originally scheduled for July 19, 2018, was pushed back to August 9th to give the special prosecutor time to get up to speed. And when the case finally went to trial, Claps waived his right to a jury and chose a bench trial instead. Now, during this trial, prosecutors played the surveillance footage and called the 2 sheriff's deputies to testify. Both insisted the object was a real firearm, but Claps's lawyer, Thomas Breen, pushed back hard, arguing that the item was never recovered nor examined, and suggested it might have just been a replica, a cap gun, or even a water pistol. He points to the deputies' failures to report the incident before Claps walked out of the courthouse, because if that had happened, the alleged gun could have been collected as evidence to prove without reasonable doubt that it was indeed a firearm. In the end, Judge Bermilla sided with Claps. He acquitted him, saying there just wasn't enough proof that what fell was an actual firearm. He also noted the deputies' hesitation and lack of urgency didn't really align with how they'd act if a real gun had dropped. Claps, visibly emotional, wiped away tears as the ruling was delivered. But the verdict didn't sit well with everyone. Critics, including an investigation by Injustice Watch, pointed out troubling disparities in the justice system. They identified 14 cases in Cook County since 2015 where defendants of color were convicted on gun charges with even less evidence, sometimes just on testimony alone, without a weapon ever being recovered. The report raised concerns that Claps may have received preferential treatment because of his status as a judge. Either way, though, Claps is still on administrative duty. No other legal cases have been made against him, leading a lot of people to wonder just how much protection a judge really has. And are we looking at a case of double standards when it comes to accountability in the justice system?
A Hamilton County magistrate says he was forced to resign or be terminated after being accused of putting his hand on a defendant.
This video shows Hamilton County Common Pleas Court Magistrate Michael Bachman. He leads the woman from an elevator to the courtroom. Bachman resigned after this incident.
On September 4th, 2018, former Hamilton County Magistrate Michael Bachman resigned after a controversial courtroom incident in which he physically confronted and jailed a woman named Cassandra Jackson for screaming in a courthouse hallway. Now, Jackson, a 28-year-old single mother of two, had arrived at the Hamilton County Common Pleas Court in Cincinnati, Ohio, just before 7:45 a.m. to file a civil stalking protection order against someone from her church. But when she spoke with the court staff, she was told she had missed the 8:10 a.m. deadline to have her case heard that day. Upset and frustrated, she gets into a heated exchange with staff just outside Bachman's courtroom. At the time, Bachman was presiding over an asset forfeiture trial. But during that argument, Jackson let out a single scream, just 1 second long. But it was loud enough to disrupt the proceedings and prevent Bachman from hearing a witness. Bachman, who was then serving as chief magistrate, got so angry that he left the bench and followed Jackson down the 5th floor hallway. He passed the elevators and catches up with her near a staircase, pointing and ordering her to return to his courtroom. When Jackson hesitated and started to turn down a different hallway, surveillance captures Bachman placing his hand on her neck and shoulder, guiding her back to the courtroom. He then directed her to sit in the jury box. Once back inside, Bachman charges Jackson with contempt of court for disrespectful and disruptive behavior. He sentences her to 3 days in jail. And when Jackson resisted arrest, struggling as deputies try to handcuff her and threaten her with a taser, Bachman extended her sentence to 10 days. Jackson, visibly distressed, said that she felt abused and afraid for her safety. She emphasized that she was only trying to protect herself and her children. 2 days later, on September 6, 2018, presiding Judge Kim Wilson Burke reviews the video and ordered Jackson's release, dismissing all charges. Bachman also resigned just a few days later, on September 10th, after court administrator Patrick Dressing told him that he'd be fired if he didn't step down. In his defense, Bachman claimed that he never choked nor manhandled Jackson, stating that he only guided her back to the courtroom to address her disruption. He said that he regretted the incident becoming public and would have defended himself if an investigation had moved forward. However, on December 18, 2020, the Ohio Supreme Court suspended Bachman's law license for 6 months. The court had found that he had shown a clear lack of patience, dignity, and courtesy, and had a total disregard for Jackson's well-being. They also noted that he showed no remorse during his disciplinary hearing and that his behavior undermined public confidence in the fairness of the judicial system. But just when you think Bachman's resignation would seal the case for good, that lady, Cassandra Jackson, wasn't about to let him go so easily. She files a civil rights lawsuit against Bachman, claiming her First and 14th Amendment rights were violated, and also brought state law claims including assault, battery, negligence, and emotional distress. Bachman tried to have the case dismissed by citing judicial immunity, but Jackson appealed the case, stating that in Bachman's 10 years serving as a magistrate, he'd only issued nearly 40 contempt orders that resulted in jail time for minor infractions such as profanity or disruptions. Right now, there are no records indicating whether that appeal or the case in general is still active in court. However, the most recent available update, dated back on September 27, 2021, showed multiple mediation attempts and scheduled briefings. So hopefully both parties have been able to reach some kind of resolution on their own.
It was the outburst that got a Brevard County judge in some hot water. Judge John Murphy is accused of throwing a tirade in court and beating up an attorney. Now Judge Murphy could be punished.
When former public defender Andrew Weinstock walked into court, it was the first time he and Judge John Murphy had seen each other face to face since Weinstock claims he was punched in the face by the judge.
Now, it's one thing for a judge to settle a fight in court, but it's a whole different story when that judge is the one throwing the punches, and the whole thing was caught on camera. June 2nd, 2014, Brevard County Judge John C. Murphy gets into a heated and highly publicized confrontation with Assistant Public Defender Andrew Weinstock. It all started during what was supposed to be a routine criminal court session in Viera, Florida. Murphy became visibly frustrated when Weinstock refused to waive his client's Sixth Amendment right to a speedy trial. Murphy, who happened to be a retired U.S. Army Special Forces colonel with service in Afghanistan, lashed out at Weinstock, shouting,
This is an emergency. If I had a rock, I would throw it at you right now. Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No, I'm the public defender. I have a right to be here, and I have a right to stand.
I said sit down.
When Weinstock stood his ground and insisted on his right to represent his clients, Murphy fired back with a stunning challenge.
If you want to fight, let's go out back, and I'll just beat your.
They walk out of the courtroom and get into a physical altercation in the hallway. Now, there are no security cameras in that area, but courtroom audio captured Judge Murphy yelling,
"All right, you want to fuck with me?"
followed by the unmistakable sounds of a scuffle. According to Weinstock, Murphy grabbed him by the collar and punched him twice in the face. Murphy, however, claimed Weinstock was the aggressor, saying that he was struck in the chest first. A nearby deputy had to step in to break him up. After the fight, Murphy came back into the courtroom and resumed his docket, handling 8 cases without Weinstock present, leaving those defendants without legal representation. In one of those cases, a confused defendant ended up waiving their right to a speedy trial at Murphy's suggestion. And the Florida Supreme Court later ruled that this act violated judicial conduct. While some in the courtroom clapped and laughed after that bizarre showdown, the incident quickly went viral and became a national spectacle. Weinstock later said that he and the judge weren't really the best of friends. He recalled previous tense encounters where Murphy had suggested they discuss issues in the hallway, but said he never expected it to get violent. Now, by the way, Murphy had been elected to the bench in 2006 and re-elected in 2012. But after that incident, he takes a 4-week paid leave, undergoes anger management counseling, and issues a public apology. Meanwhile, Weinstock resigned from the public defender's office, particularly after his supervisor, Blaise Tredis, supported Murphy's return to the bench in July 2014. The Florida Judicial Qualifications Commission, or JQC, however, launched an investigation, accusing Murphy of violating both the Code of Judicial Conduct and the Rules of Professional Conduct. The charges included threatening violence, engaging in a physical fight, and proceeding with court cases without ensuring defendants had proper legal representation. The JQC recommended a 120-day unpaid suspension, a $50,000 fine, continued mental health therapy, and judicial education courses. The court ruled that John Murphy was unfit to continue as a judge, and as such, he was removed from office. Murphy's legal team argued that his PTSD from former military service should have been considered a contributing factor, not an excuse, and asked the court to reclassify his removal as disability-related. But on January 13, 2016, the Supreme Court denied that request, making both Murphy and Weinstock losers in the end.
A Broward court judge is off the bench tonight, suspended by the Florida Supreme Court. Judge Gina Hawkins allegedly grabbed a court employee by the neck and shook him.
The Florida Supreme Court released this video Friday showing Broward Judge Gina Hawkins in a hallway briefly putting her hands on the neck of a court employee and shaking him. Then she had an animated conversation with the man.
On June 11, 2019, Broward County Circuit Judge Gina Hawkins was caught on courthouse security footage placing her hands around a court employee's neck and shaking him, an incident that sparked a high-profile disciplinary case and ultimately ended her judicial career. This all happened in a secure hallway of the Broward County Courthouse. Hawkins, frustrated that her 2 p.m. docket papers weren't ready, went looking for the employee, Robert Grieper, who was working in another judge's courtroom at the time. According to the Florida Judicial Qualifications Commission, Hawkins motioned for Grieper to step into the hallway, and that's where she briefly grabbed his neck and shook him before launching into a heated discussion, all of which was captured, though silently, on surveillance video. Grieper later described Hawkins as wide-eyed and extremely upset, clarifying that she didn't apply pressure, but the gesture still shocked him. Initially, Hawkins tells the JQC that she never touched Grieper, claiming that she had merely invaded his personal space in a joking manner. But then she saw the footage and admitted that, yeah, there was physical contact. She also said the reason for her initial denial was that the video was a little blurry and her emotions were heightened at the time. Yeah, but the JQC didn't buy that explanation. It deemed her behavior wholly inappropriate and in direct violation of the Florida Code of Judicial Conduct. They said that she failed to promote public confidence in the judiciary, did not act with dignity and courtesy, and undermine the integrity of the judicial office. They called her actions potentially criminal, especially since they appear to be motivated by anger. So on July 18, 2019, the JQC recommends that Hawkins be immediately suspended without pay, and it wouldn't take a day for the Florida Supreme Court to agree and enact that suspension. Now this was kind of crazy because Hawkins had been appointed to the bench less than a year earlier in November 2018 by then Governor Rick Scott. Prior to that, she served both as a prosecutor and a private attorney. She had a clean professional record, so to get her job back, Hawkins offered an apology to both Greiper and the JQC, letting him know that she only put her hands on him as a joke, nothing more. But since Greiper had a whole different story and another employee said Hawkins demonstrated a choking gesture while discussing the incident, Hawkins was forced to resign. So we want your opinion. Do you really think Hawkins had any bad intentions, or was this just a case blown out of proportion?
When a defendant refused to go willingly into custody, the judge shed his robe and helped the court officer restrain him.
In December 2015, a tense moment unfolds inside a Jackson County courtroom when Circuit Judge John McBain physically stepped in during a scuffle involving defendant Jacob Larson. Now for context, Larson was accused of stalking a former high school classmate, sending her 22 Facebook messages, showing up at her workplace, and even leaving flowers. All despite a protection order Judge McBain had issued in August 2015. So during this hearing, Larson's behavior turns confrontational. He accuses McBain of being buddy-buddy with the woman, showing no remorse, and escalating the tension in the courtroom. McBain initially sentenced him to 3 days in jail, but as Larson kept arguing and refusing to cooperate, well, that sentence was quickly bumped to 93 days.
93 days in the county jail. You want to go for a year? Try it right now. One more word out of you, it'll be a year of county.
Things spiraled further when a court officer tried to handcuff Larson and he resisted. That's when the judge takes matters into his own hands, literally throwing off his robe, shouting,
"Tase his ass right now,"
and joins the court officer in restraining Larson on the floor. Fast forward almost a year, and that dramatic moment caught on camera went viral, sparking a flurry of public debate. Jackson County's Chief Circuit Judge Thomas Wilson defended McBain, saying that judges have a duty to maintain order in their courtrooms. But the Michigan Court of Appeals later suggested that McBain's conduct might merit an investigation by the Judicial Tenure Commission. McBain, who'd previously worked as a prosecutor and was elected to the bench in 2002, stood by his actions. He said that he was concerned for both the court officer's safety and Larson's, especially since there was no sheriff's deputy present at the time. Judge McBain would even compare Larson's obsessive behavior to that of the infamous character in Fatal Attraction. He'd already warned Larson to stay away from the woman, but the harassment continued. Larson was later hit with additional charges of aggravated stalking, while Judge John McBain was cleared of all wrongdoing.
A judge ordered a deputy to use a taser on a defendant who kept talking after the judge ordered him to stop, and now the judge is being disciplined.
Maryland Judge Robert Nally caught on camera ordering a deputy to stun a defendant in his courtroom.
On July 23, 2014, Maryland Circuit Court Judge Robert C. Nally triggered serious legal and professional fallout. You see, during a pre-trial hearing in Charles County, Maryland, Nally ordered a deputy to activate a stun cuff on 25-year-old defendant Delvin L. King. King, facing gun possession charges and representing himself, had been fitted with this device, a restraint capable of delivering a 50,000-volt shock, due to his previous attempts to flee a court proceeding. So this all goes down while Mr. King was citing case law that Judge Nally found irrelevant. King kept speaking despite being told to stop many times. So a frustrated Nally directs the deputy to activate the stun cuff. King collapsed, screaming in pain for about 5 seconds, until Nally abruptly recessed the hearing. The courtroom video would capture King's visible distress. Some prosecutors then noted that King hadn't even raised his voice or acted in a threatening manner, calling Nally's decision highly disproportionate to what amounted to verbal interruptions. King himself later described the experience as torture and dehumanizing, saying it undermined his ability to defend himself when the trial resumed. And though he was initially convicted by a jury, that wouldn't be the end of his story. Nally, who had served as a judge since 1988, was removed from the bench by Maryland's Court of Appeals in September 2014. Then in February 2016, Nally pled guilty in federal court to a misdemeanor civil rights violation. He admitted that using that stunt cuff was objectively unreasonable. And so on March 31st of that same year, U.S. Magistrate Judge William Connolly sentenced Nally to 1 year of probation, a $5,000 fine, and mandatory anger management classes. Maryland's highest court also banned him from ever returning to the bench. But that's not all. In March 2017, King filed a $5 million federal civil rights lawsuit against Nally, arguing that the judge's actions caused him extreme physical pain and public humiliation, especially with the incident captured on video and widely circulated online. The lawsuit asserted that King posed no threat, making the use of the stunt cuff entirely unjustified. But at this point, it just felt like Mr. King was trying to profit out of the situation, so his case was dismissed. And probably the wildest part of this story is that this wasn't Nally's first run-in with the law. Way back in 2010, he pled guilty to deflating the tires of a car parked in his designated courthouse space. And that just has to be one more reason for people to believe he's just a very bad person. Now, this judge wasn't caught on camera doing anything particularly bad, but rather he was doing what any good judge would have done in his position: fight for justice. Let's go to March 11th, 2015. Seminole County Judge Fred Scott makes headlines after publicly scolding Assistant State Attorney Diana Myers and overturning a jury's guilty verdict in a DUI case involving 46-year-old Lisette Gonzalez. The dramatic moment came at the end of a one-day trial. Gonzalez had been arrested on November 15, 2014, by Officer Michael Wagner, who claimed he saw her drinking from a can of natural ice beer while driving along St. John's Parkway. Wagner took her to the Seminole County Jail, but later testified that no one was available to administer a breath alcohol test, so he books her without one and leaves. Now, despite that, Wagner checked a box on that DUI citation indicating Gonzalez's blood or breath alcohol was over 0.08, the legal limit in Florida. That checkbox alone triggers an immediate suspension of her driver's license. Then, 2 months later, on January 15, 2015, she's pulled over by an Altamonte Springs officer and ticketed for driving with a suspended license, a direct result of Wagner's citation. This chain of events outrages Judge Scott, who believes that Wagner's action went beyond a simple error. In open court, Scott accuses the officer of perjury, saying,
"Did you hear the uncontroverted testimony of this officer?"
Your Honor.
Then I want you to take him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely not,
citation.
Your Honor.
Since that officer lied, Judge Scott said that Wagner was charged wrongly. Myers pushed back, saying that the mark was just a mistake, but Scott's not buying this. He found the evidence in the DUI case too weak to even support the jury's guilty verdict and issued a judgment of acquittal, also known as a JOA, which effectively overturned Gonzalez's conviction.
That is not true.
I'm dismissing. I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
Just so you know, a judge issuing a JOA is very rare. Like, judges almost never overrule jury verdicts on the spot, let alone in such a heated courtroom exchange. But even with the judge's decision, the case wasn't over. Assistant State Attorney Tom Brigman announced plans to appeal the acquittal, hoping to reinstate the jury's original verdict. Meanwhile, the public defender's office pushed back, arguing that retrying Gonzalez would violate her protection against double jeopardy, since technically she'd already been acquitted. Still, a new hearing was scheduled for April 2nd, 2015, this time with a different judge. And according to public records, it's unclear whether Gonzalez was ever prosecuted again. Our guess would have to be probably not. Judges are known to throw the book at criminals, figuratively. But in this case, Judge Richard Scotti took that a bit too literally and actually hurled the U.S. Constitution across his courtroom. It's February 14th, 2017, Valentine's Day in Vegas, but there's no love in this courtroom. Judge Scotti, a Clark County District Court judge, erupts during jury selection in a disturbing child rape case, one that would eventually implode thanks in part to his outburst. The trial involved Jose Azucena, a man accused of luring children with candy and sexually abusing them for 2 years in his Northeast Valley apartment complex. He faced 25 felony counts and 5 gross misdemeanors, with charges like sexual assault of a minor under 14, first-degree kidnapping, and lewdness with a child. However, it got out of control during jury selection when one prospective juror, a nurse, told the court she couldn't be impartial due to her exposure to child abuse at work.
Okay, so can you be fair to both sides?
I think I would be biased. I don't know how.
You didn't say that yesterday.
Well, I said I had
No, listen, what we're not going to have in this jury is people coming in overnight and thinking up and trying to make it up now.
Judge Scotti wasn't having it. He accuses her of faking an excuse to avoid jury duty and snapped, both verbally and physically, throwing a pocket constitution against the wall and warning her about the consequences of being dishonest.
Why can't you're saying that you can't be fair and impartial to both sides. You're going to completely throw out our entire justice system because you don't want to be fair and impartial.
And then he sent her home. Now, when that surveillance footage was made public, the Nevada Supreme Court was not impressed. In their view, Scotti had created an intimidating atmosphere, one that may have scared other jurors from speaking up about potential biases. And that turned out to be a big problem. On September 5th, 2019, Azucena's conviction and life sentence were overturned by the state's highest court. The court claimed that Scotti's behavior undermined the integrity of the jury selection process, and Azucena was remanded to prison on another conviction, pending a retrial. Meanwhile, Judge Scotti's troubles were just getting started. On September 15th, 2020, the Nevada Commission on Judicial Discipline filed ethics charges against him, citing violations of judicial conduct, including his failure to act with patience, dignity, and courtesy, and for damaging public confidence in judicial impartiality. Scotti eventually expressed regret in a letter to the Nevada Commission on Judicial Discipline, letting him know that he only acted that way because inconsistent excuses from potential jurors were getting on his nerves, and he only wanted to keep the trial fair. But not everybody's buying this, and that's because Deputy Public Defender Carly Kearney, who would later run against him in 2020, witnessed that meltdown and at the time moved to dismiss the entire jury pool, arguing the incident could intimidate jurors from being honest. But Scotti rejected her motion. So, if he really wanted to keep the trial fair, why didn't he dismiss the jury pool? Well, Scotti was elected to the bench in 2014 after a 26-year career in complex litigation. But after that incident and the ethics charges, his re-election campaign took a nosedive. Kearney, with a fraction of his fundraising power, won the seat. That outburst from 2017 became the centerpiece of her campaign, making people know that he probably had a pattern of judicial temper issues. Even Scotti admitted fault in the aftermath, saying,
"I have no excuse. I apologize. I overreacted. I've learned from this mistake. I've been better since then."
He would try to pivot, branding himself as a reform-minded voice for the justice system. But again, critics weren't convinced. I mean, they really just couldn't trust this guy anymore. And Kearney, along with other legal experts, pointed to other occasions where Scotti's temper just got the best of him, like clashes with court clerks and having lawyers escorted from the courtroom, proving that the 2017 outburst wasn't a one-off. But undeterred, Scotti re-enters politics in 2021, announcing a bid for the Nevada Secretary of State as a Republican. He leaned on his background as a lawyer, judge, and a business owner, and campaigned on election integrity and constitutional values. But that campaign fizzled out, and Scotti returned to private practice. founding the Scotty law firm with his son, Nicholas. As of July 2023, he was also serving as an administrative law judge for the Nevada State Contractors Board. So despite the explosive 2017 moment continuing to haunt his legacy, Scotty still retains a reputation for legal competence. He's holding an AV preeminent rating from Martindale-Hubbell and has received nods from the American Bar Foundation. Supporters writing letters to the Las Vegas Review-Journal have defended his character, but critics just can't seem to let go of that constitutional toss, along with other controversial decisions he's made as signs of his poor judgment. As of right now, there have been no new developments in the Azucena case or Scotty's disciplinary record, but that infamous moment when a judge throws the U.S. Constitution in court still stands as a defining and bizarre chapter in Nevada's judicial history. I mean, that was just crazy.
You